But yes, I'm James Brown, one of the solicitors at SEN Legal. I'm seeing, looking down the list of attendees, I obviously know quite a few of you, but for those of you who don't know me, I am one of the solicitors at the practice. And what I'm going to be talking to you today about is what we work as SEN Legal does for schools. Many of you will be aware of what we do for parents, but we also do a considerable amount of schools work as well. So I'll just try and share my presentation now as well. I can do that. Can you see the presentation? Brilliant. It's going a bit smoother than what I thought it might do. So briefly speaking, so what I'm going to talk about is the schools work that SEN Legal does, and in particular in relation to that is the specific area of the misuse of statutory duty to admit, where local authorities are actually placing children in schools where it's not appropriate to do so. So just moving briefly on. So the sort of variation of work that we do for schools at this moment in time is quite varied. So if you look down the list of what we do at this moment in time, it ranges from Ofsted inspections, which includes complaints, judicial review and injunctions where appropriate. There's also disputes with top-up funding, delegated budgets and local authorities' financial obligations to schools. There's also the non-payment of fees by local authorities, refusal to pay fee increases or requests for fee reductions, and quite crucially, unfunded EHC plans and the misuse of statutory duty to admit. And that's the areas that I'm going to focus on in this talk today. But I think what you can see is that there's quite a running theme of what's going on with our work, and it all resolves around sort of local authorities and their unwillingness to provide the correct level of fundings to schools, and in order to pay the proper money due for EHC plans. So looking specifically at the misuse of statutory duty to admit, what do I actually mean by that? And many of you will be aware as to what happens in the SEN legal world. So when an EHC plan is issued, if a school is named in Section I, certain schools will be under a statutory duty to admit once that EHC plan has been issued. And that's regardless of what is put in Section B, so what the needs of the child are, and what the provision is in Section F. So regardless of what's actually in the plan, the school is under a duty to admit the child, provide an education. And whilst that sounds fine in practice, what is happening throughout the country is what we've found is that actually schools are being inappropriately placed in Section I, and schools are stating to local authorities, well, we don't have the provision to meet those needs in the plan. We need X amount of funding to do so, or we're completely unsuitable for the child. And despite those objections being raised to the local authority, the local authority is still going ahead and naming that school anyway in Section I, which is leading to the the sort of untenable provision for schools in the fact that they can't deliver the provision which a child needs, or they're having to spend throughout their budgets which aren't designated for SEN to meet those needs, or it's simply not being delivered at all, which obviously has a knock-on effect for a child who's not going to receive the provision that they need from the EHC plan. So it's an untenable situation for both. And what you can find is that schools can challenge this, and it's not probably well known to many of us, but there is a challenge process for schools to be able to kick back at the lack of funding and actually object to being named in Section I of the EHC plan. So I'm just going to cover in this talk what the law says about that, what the recent case law says about that, because there is a 2019 case law which is really relevant to this point, and what schools can do to challenge this, which is obviously the important factor of that. So looking in a bit of detail as to what the law says, Section 43 of the Children and Families Act provides the duty to admit. So if you are one of those schools contained in the list on the slide, so that's a maintained school, maintained nursery school, an academy, an institution within the further education sector in England, or a non-maintained special school, or an institution approved by the Secretary of State under Section 41, you will be under a duty to admit if you are named in Section I of the EHC plan. So when you're looking at that list, what importantly it doesn't apply to is the independent schools which aren't Section 41 registered. This duty to admit does not apply to you, but for everyone else it does. What the law then goes on to say in Section 39 of the Children and Families Act is that the local authority, before naming a school on that list, must consult with that school specifically and carry out a consultation process as to whether or not they should be named in the HC plan. So there's a duty to consult from the local authority. Local authorities have to carry out that consultation process. What then happens with, again, under Section 39 of the Children and Families Act, the local authorities in that consultation process, the schools will have a chance to respond to that consultation and say whether or not they believe themselves to be suitable and whether or not they should be named. And the school will not be named if subsection 4 applies, which is the exceptions to the duty to admit under Section 43 of the Children and Families Act. Unless subsection 4 applies, though, the school will be named in the HC plan. The local authority have to name that school in Section I, and the duty to admit will apply from Section 43. Looking at the subsection 4, which are the exceptions are twofold. It's either subsection A or subsection B which applies, and subsection A is the school or other institution requested is unsuitable for the age, ability, aptitude or special educational needs of the child or the young person concerned, or B, the attendance of the child or young person at the requested school or other institution would be incompatible with the provision of education of others or the efficient use of resources. And for those working in the SEN world, I think you're probably all quite familiar with that subsection B particularly, and I've highlighted that in bold because that's the more pertinent points to make if you are a school looking at these consultation documents, because you can set out quite clearly to local authority why that applies. Rather than focusing on subsection A, which is effectively saying to the local authority and the parent who's requested you to be named that you're completely wrong on this point, where you're not going to get very far with that argument. Whereas if you use subsection B, it's a lot stronger and pertinent point to raise. And I'll come on to that in a bit more detail throughout the presentation. If subsection 39, the subsection 4 applies, the local authority then has to move on to subsection 5. Which is that the local authority must secure that the plan names an alternative school, which the local authority would think would be appropriate for the child, or specifies the type of school or other institution. So therefore, if subsection 4 applies, the local authority should in theory be looking at alternative school options. Further, if subsection 5 applies to the Act, then the local authority must secure that the plan provides for a child or a young person to be educated at mainstream school. Parents have a right to mainstream education, children have a right to mainstream education, and that only won't apply unless it's incompatible with the wishes of the child's parents or young person or the provision of education of others. If that duty is applying and the local authority try and rely on the exception in subsection 2b, well, it's going to be quite hard for them to prove that because they have to take reasonable steps in order to prevent the incompatibility. So they would have to, in theory, spend money to make that school appropriate for the child. Just to round off the picture in terms of legislation, Section 40 is where there is no request for a specific school to be named in the HC plan, and therefore the local authority must only secure that the plan names a school or other institution which the local authority thinks would be appropriate for the child. So the relevant legislation before doesn't apply in that situation. Just a quick summary of those points just before we move on to what's actually happening in reality of those in this process. The parents have a right to nominate which school they want named in the HC plan. That's a right of the parents to have. The local authority have a duty to consult with that school that the parents have requested, and unless the exception applies within Section 39, subsection 4, the local authority will be bound to name it. If the exception does apply, then the local authority will have to name an alternative school under Section 39, subsection 5. And importantly, parents have a right to mainstream education unless the exception in Section 33, subsection 2 applies. But the local authority, in order to rely on that, will have to show there is no reasonable steps to prevent the incompatibility. So the local authority will have to get a watch out and spend a bit of money to make sure the school is suitable. So looking at how the law really ties in with this and what's happening in practice, in an ideal world, it all sounds quite straightforward. The school will say, well, we can't meet needs, we don't have that level of provision, you can't place the child there unless you give us X, Y amount of money. And unfortunately, we don't live in an ideal world with the SEN world. It's far from an ideal world, and local authorities' budgets very much dictate what they do in the decision making. So looking at what's happening in reality, The consultations are not being sent by the local authority, for example. The consultation process is not carried out. Children and young people have been inappropriately placed in unsuitable placements. Consultations are often being sent by schools, and schools are detailing why they shouldn't be named and what this subsection applies, but they're being ignored by the local authority. An important point is that provision of EHC plans are often being reduced to fit the school rather than meet the needs of the child. And that's happening more and more, and that you'll see that in the case of the Academy Trust v Midway, in the Midway Council case, where that was set out, and that was actually happened by the local authority. But it's also happening with primary to secondary transfers, for example, where the EHC plan contains quite a specific level of provision, but the school set out in the consultation process that they can't deliver that provision. Often local authorities are actually seeking to reduce that provision, so the school can actually say, well, yeah, we can meet these if that provision is taken out, which is obviously totally inappropriate for the child and totally inappropriate for the school, because the school aren't going to be able to meet the needs, which could have a knock-on effect for the education of others and for the education of that child. The child's needs won't be met if the provision is not in place. What's also happening more and more in practice is that insufficient level of funding is agreed to deliver the provision. So local authorities will often refer to banding levels in EHC plans, funding levels in EHC plans. They'll refer to band 1, band 2, band 3, for example. Those different local authorities have different banding categories, but often the banding doesn't actually deliver the provision which is needed. There's not actually enough funding within that band to deliver the provision, which is unlawful. The local authority have a duty, which Haley has gone on in section 42, to deliver the provision in the plan. It's not for the school to deliver it, and simply saying that there's enough funding in a band to deliver the provision is not going to be sufficient for local authorities to get away from that duty, and it can be challenged. And there's also the reference to the notional budget within these EHC plans, which says the first £6,000 worth of provision will be met by the school from their notional SEN budget. And I would say that's a very hypothetical situation, which EHC plans shouldn't really be dealing with hypothetical situations, because once you look into a school's budget and the notional SEN budget they receive, you often see that actually that £6,000 doesn't actually exist, and the school doesn't actually have £6,000 to fund that first initial bit of funding, and there's often a shortfall in that. So, for example, schools will often only have, in theory, in practice, actually, £3,000, for example, rather than £6,000. They're already at a considerable shortfall at that point. So that insufficient level of funding, and that applies not just to the misuse of statutory duty to admit, that actually applies to schools currently sitting here watching this presentation with the EHC plans in place already, and that level of provision not being in place with the children they have at their schools. And some of you may already be thinking, well, actually, we are massively overspending from our own budgets in order to deliver the provision, for example. And that's not right. That's not what should be happening according to the law, and you can seek to challenge that. And what's important to remember is that once named, the school will obviously have a duty to admit under section 43 of the Children and Families Act. So even if these circumstances do apply, you still have to take the child in. So then leads to the question as to what can schools do about that. And this can be challenged, and it can be challenged through way of judicial review, for example. And the case of our Academy Trust and Midway Council, which is a 2019 decision, which I'll come on to in the next slide, highlights that point. And it's not just academies that can challenge this either. It's actually local authority maintained schools can challenge this. And that's what happened in the Queen's Mead school case in 1997, where a maintained school took on the local authority for slashing their SEN budget, which left them unable to deliver the provision within the statements, as we know to be EHC plans now. And they were successful in that challenge, and the local authority, because they were on a duty to provide the provision, had to increase the level of funding back into the school. So the school were actually able to take on the local authority in that case. So just moving on to the case of Midway in a bit more detail. And I'll just run through the brief sort of facts of it. It's not a complete factual account of it, but it's a brief one. So it was a judicial review claim brought by an academy against Midway Council when an autistic boy moved from a different local authority, Midway. The school successfully challenged the EHC plan being named within Section I. Midway Council consulted with the school, and the academy responded, setting out the reasons why they were unsuitable. The EHC plan contained specific provision within the school which the school were unable to deliver or offer. They needed an additional funding in which to do so. The Academy stated they would need £40,000 worth of funding to meet the need based on the EHC plan and the expert evidence which supported the EHC plan. Rather than finding an alternative school, the local authority simply amended the plan to remove the specified provision and named the school in Section I. Midway Council actually increased the top-up funding by only £9,000, which left the EHC plan completely worthless and the school unsuitable for the child because they couldn't deliver the provision that the school needed. However, because of the duty under Section 43 to admit the child, and once they were named in Section I, the school had a duty to do so and would have had to admit the child. In response to this, the Academy Trust submitted a complaint to the Secretary of State of Education against Midway's decision to name them in Section I. The Secretary of State dismissed the complaint and upheld Midway's decision, even though the facts were so clear of what was going wrong there. A judicial review claim was subsequently issued, and the Academy Trust were actually successful. The EHC plan naming the school was subsequently quashed, and the local authority had to find an alternative school for the child. So it's a very quite important decision to highlight the issues, what's going on, but also to highlight the fact that schools can challenge this, and the High Court will listen to such complaints of this, and they will pay particular interest to the facts of the case. And it did lead to a successful decision. The grounds that the Academy Trust challenged on were the unlawfulness of the EHC plan, so completely reducing the provision in the EHC plan was held to be unlawful. The EHC plan lacking the specificity and quantification in the EHC plan, that was held to be unlawful as well. And the lack of a proper and fair consultation process under Section 39 was also held to be a ground to be challenged on. And there's no sort of set definition within the Act of what a consultation process should look like, but looking at the facts of the case of Midway, if you look at them to a bit of detail, when schools are challenging local authorities and not giving you an adequate response to those, then you can challenge that on the basis it's not a proper and fair consultation process. And there's also the interrelationship between Section 33 and Section 39 of the Children and Families Act, which I have set out previously in the slides before, so I won't go into too much detail about that. So looking at the case and specifically what can schools take away from this, well, it's quite clear that local authorities can't simply remove provision from Section A to remove the incompatibility of schools. Decisions such as this are irrational and can be challenged by way of judicial review. And that was quite clearly what happened in the case of Midway, when they were trying to reduce the provision and completely took the provision out. And that was reference to specific support for the child's ASD. The child had been attending a school with more specialist ASD provision in it. But the school, the Academy Trust couldn't actually provide that. So rather than the local authority spending the money to do so, they simply removed it from the EHC plan, which was completely unlawful. And leading on to that point is local authorities cannot simply make inadequate and unlawful EHC plans, lacking in specificity and quantification required by law. Schools can challenge this point importantly in the judicial review section. And there is an interlink between Section 33, Section 39, and Subsection 4 and Section 39. Subsection 5, which the local authorities should be applying and following. And I won't go into too much detail because I've touched on it already. But I think an important point to take from that is that there is a right to mainstream schooling, and that's a stronger right than a request to a particular school. However, what the legislation does not give is the parent an absolute right to a particular mainstream school. It is just a right to mainstream education. The local authority could have named an alternative mainstream setting in this case, and it would have been a lawful decision to do so based on the legislation. Further, what else can we take away from this case? Local authorities have to carry out consultations fairly properly with the ground challenge and the ground unsuccessful. Failure to do so could attract the attention of the High Court, and it could be held to be irrational. So when local authorities are doing this to schools and they're not listening to the consultation processes, which is happening and which we have found in practice, that is a point that you can challenge for judicial review proceedings. It's important to remember that schools named in the EHC plan have no right of appeal to the specialist first-tier tribunal, unlike parents. However, they do have a remedy to the High Court through judicial review action, and it's almost can be seen as their sort of appeal route rather than the parents' appeal route, which can lead on to judicial review action. Importantly, Midway Council are not the only local authority doing this. It's not an isolated incident. We know from practice that it's happening up and down the country with the schools that we work with currently. And I think the answer as to why this is happening is quite clear. is that local authorities don't want to pay the money to properly fund these EHC plans. They don't want to get their wallet out to have to pick up the bill for these EHC plans to properly fund schools. If they can get away with it, they probably will try and do so. So what can schools do about this? So following the Queensmead and Midway cases, there was quite clear precedence to challenge this by way of judicial review. Important has to be remembered, there is no right for appeal to the SEN tribunal for schools. So you can look at judicial review action against your local authority if this is happening to you as a school. And this is not about helping schools by not accepting pupils with SEN, it's quite the contrary. Challenging this can ensure obviously that the correct provision is in place for children and young people who are in the correct school settings. And also important that schools have enough money in order to ensure they can meet provision in the plan. And also that provision is properly quantified for the child so they have enough of the provision to meet those needs. Just to repeat the point, just to reinforce the fact that it's not isolated incidents in Midway. It really is happening across up and down the country, and we have found that. So schools need to challenge the local authority within the consultation process and on the provision of education of others with the efficient use of resources. So looking at that in a bit more detail and why that is the more pertinent point to raise, you'd be looking at factors such as what impact is the child going to have in that school. So is the school already massively oversubscribed? What classroom is the school that the child actually going into? Is there already 30 plus children in that classroom? What do the other children's needs have in those classrooms? What are the other children's needs? What sort of specialism does the child need? So if the child has severe behavioural difficulties, what impact is that going to have on the mainstream school? Does the teacher have any experience in teaching children with such severe behavioural difficulties? Is a behaviour management specialist going to be needed within the school? Is there going to be a certain level of specialist teaching having to go into school, so specialist ASD teachers, for example? And also you need to be looking at the funding points there, so looking at the notional budget and as to whether or not you do actually have that £6,000 worth of funding to provide to that EHC plan. If you don't have it, you need to set out what the shortfall is and say to local authority, we need to fund that. And also you need to look at what provision you have to be able to offer to the child. Can you meet the needs in the EHC plan? Do you need additional funding which to do so? You need to set out quite clearly to local authority how much it's going to cost them, because they are quite often ruled by their costings. It can either lead for you to get the correct provision in place or for local authority to name a more appropriate school setting. And they're the arguments that you can be making which are the most persuasive in our view. Schools can also challenge this process through a complaint to the Secretary of State, and that's what the Midway case also happened in the Midway case. And you have a right to do so by Section 496 of the Education Act. And you can ask the Secretary of State to make a decision on the circumstances. And in doing so, the Secretary of State will have to consult with the Academy. And when there is a dispute, it's only the Secretary of State or the SEN tribunal which may direct the Academy to meet the child or young person. So that sounds fine in practice, but I would have to put a massive warning point on that, because the Secretary of State, and as was the case in Midway, they simply dismissed the complaint and upheld what the local authority had already done. And they're not lawyers dealing with this at the Secretary of State. They aren't just Secretary of State office, they're employees of the government. They're not legally trained to understand the implications of legislation, for example. And often, in fact, they are actually ex-local authority employees which are making decision on local authority decisions. So you can already sort of see what way that's going to go for you as a school. And further, I would also, at this point in time especially, Gavin Williamson, the Secretary of State, is going to have a massive amount of paperwork on his desk at this moment in time. He's got to try and get schools back up and running. So at what point he's going to be able to get to your complaint is a different matter. And there's no specific timescales in which they have to respond to you. So therefore, it's not going to be the best way in order to challenge this process. What is the best way to challenge this process is pre-action protocol correspondence and judicial review claim, if the pre-action protocol correspondence doesn't work. And for those of you that aren't familiar with pre-action protocol correspondence, it's very much a formal legal letter to the local authority's legal department, setting out what is not being followed correctly by the local authority, what decision they have made in relation to the consultation process and naming you in section 9 of the EHC plan, and you can seek to set out the challenge within that letter. And what will happen is local authority will have to respond to you, their lawyers will respond to you, and they'll often respond within 14 days. It can be shorter if there is urgent circumstances, sorry. But what you will do is get a response, and that'll be a much quicker response than what you would get from the Secretary of State. And of course, the local authority is probably unlikely to just simply give in at that point and give you and reverse their decision. Of course, it's possible, but it's probably unlikely in my view. But what you can do after you've got that response from the local authority is then consider a judicial review claim in the High Court, and that is the most effective way of challenging such circumstances, as can be seen in the Midway case and as can be seen in the Queens-Mead case, where they were both successful in doing so. What you have to do in order to issue this judicial review claim is focus on what grounds you're going to be challenging on. So the facts of Midway aren't going to be applying in every circumstance. So the grounds that you would look to challenge on him, perhaps the consultation was unlawful. So was there a consultation ever carried out? Was there any consideration or response to that consultation process? If not, the decision is irrational. Is the EHC plan lawful? Is there a specific provision within Section F? Is there quantified provision in Section F? Have the local authority actually tried to minimise the provision in the EHC plan? Is the EHC plan actually completely inadequate for that child's needs? And if so, you can look to challenge that as a school within that judicial review claim. And it's also an important factor to focus on the notional budget deficit and any shortfall in funding. So if the banding that the local authority have offered you cannot meet the level of provision in the EHC plan, and you have to make it up from other budgets, well, that's unlawful, because local authority should provide it under Section 42 of the Act. So it's not your responsibility to fund that provision. And you can challenge that as you can with the notional budget deficits, if that applies to your school, which is probably likely in our view and experience. And therefore that would be the focus on the judicial review claim, and that would go through a High Court, and then the High Court would make a decision on that. And you would have a good chance of success if it was well argued. If you can show that these points apply, because that's what the law says and that's how it should be followed. Just a final point to touch on on this slide is that applies not just to the misuse of the statutory duty to admit. So if you're sat there with an EHC plan currently in place, and we've got a number of EHC plans in your school currently in place, and you know that you're spending over and above what the banding level is, and you're massively taken away from other budgets, for example, or you don't have the level of funding in order to meet the provision in the plan, then Section 42 will apply, and you can seek to challenge that, not just on the basis of the misuse of the statutory duty to admit, but also just for the fact that the EHC plans are not properly funded. Just to finally sum up on the grounds of that, just to look at what an EHC plan should say. Many of us will be familiar with the law around specificity and quantification, but just to make you aware on that point, that EHC plans do require a high level of degree of specificity, and that's what should be happening in the EHC plan. So if that level of specificity is not in the EHC plan, then you can seek to challenge it on the basis of it being unlawful. It's very much the last slide, but just a quick sort of sum up on that is, if you are going through this process and the consultation process not being followed up correctly, and a child is being named where you don't have the correct level of funding in place, and you're not in a suitable setting, for example, you can seek to challenge that, as you can seek to challenge if you are spending over and above what the local authority are offering on your EHC plans at this moment in time. So they can both be challenged by judicial review. It's not a case that you just have to simply accept it. I'm conscious that I have slightly ran over time, but that is the end of the talk. Thank you all for listening.